very, very helpful, very good point. Let's talk about objections. You want to think about your objections ahead of time. You want to get your evidence together. You want to do your good investigation. You want to find out where your strengths are, where are your weaknesses, and start thinking about that evidence critically. How will you get it in? How will the other side keep it out? And what I am recommending you do is develop a comprehensive approach to it. Don't just think, well, this, we've got a hearsay problem here, but I think, we're not offering it for the truth, or it's pretty well going to be an exception to the hearsay rule. That's not maybe the only issue. You've got to think about all of the different ways that a piece of evidence can be kept out. All of the different ways that you're going to respond to those objections and how you're going to get it in. Maybe it's not just hearsay. Maybe it's going to be character evidence. Maybe the other side's going to say that it's under 403 more prejudicial than it is probative. Just think about a lot of different ways that you're going to be able to get it in, and through what witnesses and where in the case. Side note here a little bit, and John will talk about this more in cross-examination. Where is the most persuasive, or what is the most persuasive way to get your evidence in? I'll ask you this, is it through your own witnesses?
Yeah, and that's through the other side's witnesses.
It's through the other side's
You make them your expert. Yeah.
Your jury perspective is going to say, when you call a witness to testify, oh, okay, yeah, this witness said something favorable for you. Of course you would. That's your witness. That's his witness. But when you can get that same evidence through a cross-examination of their witnesses, the other side's witnesses, man, the jury's going to look at that and they're going to say, well, man, if he said it, that's the prosecution witness. If he said it, it must be true. So that's something to think about when you're thinking about where you're going to get that evidence in. Objections. Should I object? Does it hurt me? Is this something that's going to hurt? Maybe it's technically objectionable. Maybe it's hearsay. But if it doesn't really matter, if it doesn't really hurt you, you don't want to object, because you're going to appear to the jury to be obstructionist. You're going to appear to be like you're hiding something from you. You're going to appear, this guy doesn't want us to hear the truth. That's how juries think. So if it doesn't really hurt you, there's no need to object to it. A lot of your trials can be real quiet from an objecting standpoint if the case is going all right, nothing's really hurting you that bad, or maybe you've got other ways you can deal with it, or ways to deal with it on cross-examination. Let's see here. Preserving the record. You got to make your objections on the record. The judge is either going to rule, or most of the time the judge is going to rule. Sometimes the judge is just going to say, okay, move on, or what have you. You can have continuing objections if there's something that's going to continually crop up in the case. Judge, may I have a continuing objection as to this issue? The judge is usually going to say, yeah, that's fine. And that's the better practice, as opposed to being, again, like a jack-in-the-box. The jury's going to think, what's this guy got to hide? Why is it that he keeps on trying to get that out? And the other thing with objecting is, when you object, it highlights the evidence, doesn't it? When you object, the jury's ears are popping up. They're going, uh-oh, this must be something important. Whereas, maybe it's not coming in as logical and rational and thought out as the prosecution wants it to, maybe the jury's not paying attention. Maybe you just let it slide. So a lot of different things to think about when you're thinking about when to object. Offers of proof. You want to make your offers of proof. If you're trying to put in a piece of evidence, the other side objects, the judge sustains it, you need to preserve the record by having an offer of proof for the record, what that testimony, what that evidence would have been, what that document would have said. And the best practice here is to do this outside the presence of the jury, outside the hearing of the jury. You may ask to approach at the end of that particular witness. That's probably the best time to do it, and go ahead and get that evidence in on the record. And, you know, sometimes a judge, after they hear what the evidence was, and if you think this is one of those times where the judge will, if the judge just hears what it is that I'm trying to get in, they might see it, that it's admissible. They might let it in. If that's the case, you're going to want to ask to approach right then and there, Judge, may we approach on this? The court reporter's going to be right there. You want to whisper loud enough to where the court reporter can hear, but not so loud the jury can hear. Judge, if allowed to testify, we expect this witness to say X, Y, Z. We think it's admissible because of, you know, ABC reasons. And even if the judge denies it, you've at least got your verbal offer of proof on the record. And if the judge denies it at that point, I would go back again and outside the presence of the jury when that particular witness is finished, get what that witness would have said on the record, you know, so you're preserved on your appeal. Dialogue with the judge. The judge may say, like in My Cousin Vinny, well, that's a well thought out, reasonable, rational, logical objection. And Vinny's going, yeah, that's great, that's great. Overruled. Well, why was it overruled? And let's flip it around. Let's say, for instance, he sustained the objection without giving the prosecution a chance to make an argument, without giving them a chance to respond. You know, you're in that situation. It's the heat of the moment. You're in trial. You've got all this stress and anxiety on you. You're trying to think about, what am I going to do next? Have I gotten everything in? And sometimes in the heat of the moment, we have a tendency just to, okay, well, I'm going to move on. Judge is, you know, telling you, I'm sustained. Move on, counsel. Move on. And you may feel pressured to, you know, not follow up on it. But I recommend to you, you dialogue with the judge. You talk to the judge. You say, Your Honor, and you do it with deference and respect. With respect, Judge, on what grounds are you sustaining the objection? Because haven't we all seen the judge who says, well, I don't think it's hearsay, but I think you've got to, you know, I don't think it's relevant, you know, sustain. How many times do you think that happens where the judge doesn't verbalize that thought, but that's what the judge is thinking? And you're over here going, man, I know that's not hearsay. That's got to come in. You know, and the judge is thinking to themselves, well, that's irrelevant. So you're going to want to dialogue with the judge. You're going to want to ask them, Judge, with respect, so I can know how to proceed, what grounds are you sustaining the objection on? And the judge is then going to tell you at that point, hopefully, well, I don't think it's relevant. Frankly, it's not a hearsay problem. It's a relevancy problem. At that point, then you need to go ahead and state your grounds of why you believe that it's relevant, whatever the case may be. And to give yourself that opportunity, certainly, to preserve for the record, as well as the judge may not have thought of what your response was. And the judge may say, well, you know, you've got a good point. Let me go ahead and, yeah, I'm going to overrule the objection. Let's see here. Judges sometimes don't like to rule. We all know that, right? And some judges are famous for not ruling. And most of the time it's pretrial stuff. When it comes down to trial, most of them are pretty good at giving a ruling. But some judges just don't do it. You'll be objecting and they'll say, oh, okay. They'll even listen to argument for 5 minutes. It goes back and forth and back and forth. Okay, move on. You know, Judge, again, with respect, we need a ruling. Judge, to preserve the record, we need a ruling on this issue. And, you know, your record, if you verbalize that to the judge a couple of times, it's certainly going to reflect that you were asking for one. So that can't be held against your client. And generally, if you didn't demand that the judge, or not demand, but you didn't request it, maybe the courts would say that, you know, that you should have, and that your client loses on appeal because you didn't do what you were supposed to. You didn't follow up on it, you know, that kind of thing. All right. another way to do that is to rephrase the question. Let's say the judge says, okay, I'm gonna, I've heard your objections, I'm gonna consider it, or whatever, move on. Well, Your Honor, for the record, maybe we have a ruling here. We need a ruling to proceed on this. No, you go ahead, proceed. What you're gonna wanna do at that point is rephrase the question. Ask the same question or a different question that is intended to elicit the same information. It's intended to elicit the same evidence. Quick example of that, what did Mr. Smith tell you, Ms. Jones? I'm gonna object, hearsay. And you have a back and forth, the judge doesn't make a ruling, move on. Okay, at that point, maybe you'd want to follow up with something like, what did you learn? I mean, that's still objectionable, right? And if the other side's listening, they're going to object again, and maybe you're able to force the judge's hand and get him to make a ruling at that point. Rephrase, okay, let's see here, limiting instructions. I think, was it yesterday that we heard the opening statement where, Vinny gets up and he says, everything that guy said is bullshit. Thank you. The other side object, counsel's entire opening statement's argument. Okay, I'm going to sustain the objection, and he gives a limiting instruction to the jury. Jury will not consider counsel's entire opening statement. Well, let me just say that, that's a good thing to do sometimes when you're able to keep evidence out. But maybe it already was verbalized in court, it was already stated, you're able to keep it out, the judge sustains the objection. To preserve the record, you may want to to show that you're doing everything you can, you may want to have the judge issue a limiting instruction that the jury should not consider that evidence, or that they should not consider the character evidence, for example, for an impermissible purpose, but they can only consider it for the permissible purpose. But when you do that, you've highlighted the evidence. Again, it's like when you object and you say, jury, your ears really perking up here. The judge is telling you not to view this evidence or to disregard it. Is that having the reverse effect? Is the jury seeing, oh, this is something really important, and maybe they need to pay attention to it? So just something to think about. Scrolling down a little bit here, if you can, John. And the next section on the outline is demonstrative aids. I'm a big believer in visual aids, demonstrative evidence. As I was saying earlier, I'm a little more old school with what I do, but it's so important, it's so key. Studies and the research has shown that when someone hears something, you tell them something, that they have a certain level of ability to recall that information later. How memorable is it, okay? And that's kind of down here. But if they see it, then their ability to recall rises, and it rises significantly. So if they can see it in writing, if they can see a picture, if they can see a diagram, their ability to later on remember it is going to be enhanced. Now, if they hear it and they see it, that's like, the golden goose. That's the best way for them to be able to remember it. And so that's what you want to do. Everything that you show to the jury does not have to be admissible. Visual aids, they may object to, judge, that hadn't been admitted into evidence, whatever it is. Maybe you're writing some things down during your closing argument or your opening statement. Judge, that hadn't been admitted, they shouldn't be allowed to do that. And your response is, Judge, this is just for illustrative purposes only. It's a visual aid, it's helpful to their understanding, and the judge is usually going to let that in. Even when you're cross-examining witnesses or you're direct examining your witnesses, and you write up a key point, or maybe the witness is being evasive on cross-examination and not answering the question. Go over to your board and write down the question. Write it down word for word, and see if that doesn't get their attention. The other side might object, but I don't think so.